Russia, Kazakhstan, and Belarus, as you all well know, have been cooperating before the Union came into existence. They cooperated within the framework of EurAsEC, and remain the same. Association as the Eurasian Economic Union is a very short term to draw any kind of a bottom line. I shall be very brief, and I shall give you a concise overview of the achievements during the last 12 months. First of all, year 2014 has been very rich for our integration. I'm saying so because Armenia joined the Union in October 2014, and Armenia became a full member of the Union as of the 2nd of January 2015. In December 2014, the Kyrgyz Republic signed the agreement and joined the Union, and hopefully the agreement shall be ratified very soon, and the Kyrgyz Republic will become yet another full member of the Union. The Eurasian Economic Union is a very young formation, but even today we can see a great interest demonstrated by a number of countries. Free trade agreement is being prepared with Vietnam, and we are discussing special free trade regimes with Israel, India, and other countries. The Eurasian Economic Union is based upon the pillars of 4 freedoms: the freedom of movement for capitals, goods, services, and people, which means we have to overcome a lot of barriers still in existence between our countries. The very treaty has overcome 29 different barriers. We have analyzed the key surviving barriers and limitations in the internal market of the Eurasian Economic Union. This analysis has been presented recently to the heads of state. We are now working at eliminating those barriers. During the last 12 months, we have drafted the key targets for our macroeconomic development of the Union and microeconomic development of individual countries. We are targeting macroeconomic stability, and we are targeting specific indicators of macroeconomic stability for each of the member countries. We are also targeting restoration of economic growth. Once the Eurasian Economic Union came into existence, the relevant currencies of all the member states were depreciated, which, of course, brought down the level of mutual trade and the goods turnover between the member states. Some of the Union member countries could not achieve the targets of foreign trade, which of course was detrimental to their relevant economies. With this regard, coordination of foreign exchange policies of the member states becomes of paramount importance. The financial regulators are planning to meet and discuss to which extent this harmonization is possible with regard to foreign currency policies of the Union and of the member states. It's very important to increase the use of national currencies in mutual trade, which will bring down the risks existing as of today. Of course, the customs union remains to be operational, and it's important for harmonization of customs and tariff regulation. We have single tariffs for the members of the Union, and we are coordinating our customs regulations. In 2014, the Commission initiated the consideration of a new customs code. It's now under consideration for future approval by each of the member countries. This new code will accommodate new realities and new technologies, including conversion to paper-free document turnover and reducing the time for customs clearance. It also provides for Authorized Agents Institute, which will expedite border crossing time by the goods, and it will also facilitate contacts between the taxpayers and the importer, the taxpayers, which are the goods importers and the customs authorities. All that serves fighting corruption risks. We now have 10 new technical regulations. We are close to completion of work related to 21 other technical regulations. The technical regulations are a very important area, because once we get this effort completed, all the countries will start operating under the single set of regulations. We are working at creating a single market for pharmaceutical products and medicines, for which we need single trade principles and guidelines. The future agreement provides for setting up the common market for pharmaceuticals and drugs by the 1st of January 2016. We are harmonizing industrial policies in a number of industries of our countries. We have already drafted the roadmaps targeting enhancement of cooperation and decreasing the volume of mutual trade. The national governments are involved in relevant regulation drafting. The cooperation is especially important if we speak about industrial cooperation and further possible specialization of member countries with regard to the possible return on investment. The supranatural competencies can be further identified, and that is one of the prospective fields of our cooperation. This requires an in-depth comprehensive analysis with assessment of risks and opportunities. The Union Treaty provides for setting up a single market for goods and services. This market shall be liberalized step by step. In 2015, we have introduced a list of 43 sectors of services to later on become the basis of the single market. The member countries shall gradually bring down the limitations in this area. In 2014, we have drafted the concept for the common energy market. That will further facilitate the stable development of national economies, energy security, and competitiveness of the member.
In the transport sphere, we have a program for the stage-by-stage regularization of carriers that are registered in one of the countries, carriage of cargoes between different countries that are members of the Union, the so-called near-distance transportation, and we already have all the documents in place. Very soon we will be able to implement these agreements. One of the most relevant issues is the taxation sphere. The taxes within the Union will include the indirect taxes and will have the responsibility for the exporter for the activities or non-activities of importers. In my view, this is an inefficient distribution of responsibilities. But the overall approach was based on the realities and on the desire of some companies to be to work under in the gray area, in the gray economy. We try to avoid double taxation, and that will hopefully lead to the increased trade turnover. One of the most efficient methods here would be to strengthen cooperation and exchange information between tax authorities of different countries. A protocol of cooperation and information exchange was signed between tax authorities of Belarus, Kazakhstan and Russia, and the Kyrgyz Republic joined them. And I think I will leave this at that. This was a very brief analysis of what has been done over the past year, since this is the main topic of our discussions today. And I'm very happy to start the second part of our panel. I will take on the second hat, the moderator hat, and I would now like to give the floor to the Minister of Justice of the Russian Federation, Alexander Konovalov. Thank you. Colleagues, friends, good morning. I would like to join our moderator in welcoming you to the 5th International Legal Forum. I'm very glad to see that this forum is becoming a bigger event with each year. It's becoming more powerful, more constructive, and it remains committed to integration processes both in the area of the former Soviet Union and beyond. From the very beginning, we were convinced that the integration model has to be one of the most relevant trends, and it's one of the models that needs to be discussed at such platforms as the forum. The forum has always positioned itself as a bridge between law and economics. And when we opened the first forum 5 years ago, I mentioned that in my speech, I stressed that in my speech, that the legal forum is usually organized 3 weeks before the St. Petersburg International Economic Forum, and to a degree it is some kind of an introduction to the economic forum. Last year the two forums switched in places, but this was only for 1 year. Hopefully we will continue with the traditional arrangement in the future. The forum has always positioned itself as a bridge between, let's put it this way, the rest of the world and the post-Soviet countries, the BRICS countries, the countries that belong to the Muslim world. It's a bridge between civilizations, between the economic approaches to the future of our countries. And since this is a bridge, it also bridges the legal systems. Our forum is a unique platform in that not only different legal professions meet here, but also different legal schools can meet here for discussions. We believe it is an important thing because it allows to multiply the results and to see the same things from different perspectives. The analysis of those integration processes that are taking place in the former Soviet countries have made it possible to sign the treaty on economic cooperation. I think it also gives food for thought, for further discussions, for further analysis. It is important that integration does not stop here. A number of countries that are beyond the post-Soviet geography expressed an interest in cooperation with this organization, and it is also possible that they in the future will become members of the Union. So this is a synergy of different approaches, the constructive diversity of approaches makes the forum unique. Our forum, however, is a functional event. So this becomes a general approach, and I hope very much that this is the approach that we will strengthen in the future, that this approach will manifest itself in some practical steps. The treaty became functional January 1st, and I'm very grateful to our moderator who started off this session with a full-fledged speech and presentation, and I think the results of this one-year work are quite impressive. These results became became possible because of a large number of people who worked together, who joined forces. And we met with representatives of several union countries at different locations in St. Petersburg. We have to understand that national jurisdictions, national legal systems need to be adapted to the integration model. We'll still need to make some steps in that direction. There are a number of processes that need to be implemented, the processes that can be performed at a supranational level. This is a subnational, so supranational level, obviously, and it's a voluntary process. There will be a lot of coordination, discussions, a lot of decisions will have to be made. Nevertheless, we have a foundation in place, and we'll start from there. A few steps towards the harmonization of legal systems, making our practices closer, are of greatest importance, and we'll definitely need to be able to do those steps, to make those steps. I don't see any barriers on this way. I'm sure that the countries will take their own pathways towards integration. Yesterday we learned with great interest, and I'm sure Minister Imashev will tell us more today about the plans of Kazakhstan for the establishment of a special economic zone, which also will have a special jurisdiction. But when we learned about it last night, we realized that this might be quite a radical step forward. But I don't think this is a step that may be seen as a too dramatic step. This is just a step that provides for additional opportunities, additional options for the implementation of economic and other projects. On the other hand, integration remains relevant, remains in demand. And there are a number of organizational and legal steps that need to support it. International integration not only aims the economic strengthening, the strengthening of economic ties, it also targets the creation of a single legal space where all the integration participants will feel comfortable. And of course, there may be different manifestations of this legal space. And we're not only talking about joint decisions that would be placed in the foundation of this supranational regulation. We also mean information, discussions of legal trends, exchanges on legal practices, additional services for representatives of the legal profession. It is quite possible that the legal support to businesses will remain one of the most important parts of all business projects. On the whole, we believe it is quite important that we see a lot of different discussions on relevant issues, and those issues include legal support to the international integration processes. The issues include improvement of regulations on competition, equal conditions and preconditions for all the members in order to ensure that the 4 pillars are implemented, the 4 pillars that were mentioned by the moderator earlier. I hope that the dialogue will be of interest not only from the point of legal professionals, but it will also help us to resolve a number of issues that our planet faces as a whole.
It will probably be right to say that by promoting the integration processes within the post-Soviet space and accommodating everybody who would like to take part in those processes, we would be happy to avoid the mistakes made in the past. Some of the unions or alliances have fallen apart. Some are trying to survive. The EU project may be a geopolitical project, but to a much lesser extent. It is based upon economic interests, and it is getting closer and closer to the global processors. It's largely a culture-based alliance. To conclude, I would like to say that the Treaty of the EU is a multifaceted document. It's a very comprehensive treaty encompassing the diverse and different aspects of the integration processes. Most probably, it does not explicitly include our cooperation in the legal area. It's no secret that all the documents mentioned by our moderator today, all the documents so well familiar, so well known to you, have been drafted with active participation of our legal departments. My ministry was involved in drafting the part covering the Russian Federation approach and standpoint. It's very important to maintain the high quality of the documents involved in the operations of the EurAsEC that has ceased its operations, but we would like to benefit by the experience gained within the Eurasian Economic Union. It's very important to do so at the official level, at the ministerial level, at the level of conceptual approaches, and of no less importance, it's to maintain it the same high quality of work and documents at the level of experts, so that our cooperation benefits from all our previous efforts. Hopefully, the St. Petersburg International Legal Forum will provide for the contacts needed for this work. I wish all of you fruitful work and thank you for your attention. Thank you very much, Minister. You're absolutely right. The EU is mostly an economic alliance. We have discussed that very openly in Astana, at the Astana Economic Forum. That's where the key ideas of our cooperation were put forward and discussed. With this regard, I would now like to grant the floor to Minister Imashev, Minister of Justice, Republic of Kazakhstan. Esteemed delegates of the conference, I would like to join my voice to those who have already thanked the organizers of the forum. Thank you for inviting me, and thank you for the business atmosphere you have created. This is a high-level event, and it's an annual event too, bringing together academia and legal practitioners, which allows us to identify problems and search for and find their solutions. providing innovative legal solutions is equally important for lawyers and other legal practitioners. It's important for our union and for the global economic processes. Globalization affects all the areas of public and societal life. We want to timely respond to global challenges. It's important to do so for the development of national economies and to generate new integration realities. Under the current conditions, it is not possible for nations to develop in silo. They have to strive for sustainable development under the trends of international cooperation. On the 29th of May 2014, we shall celebrate 1 year of signing the treaty on Eurasian Economic Union creation. As we all know, the purpose of creating the Union was securing free movement of commodities, goods, services, labor, and funds between the member states, with the single goal of enhancing their national economies. The International Economic Organization, set up in the space of the former EurAsEC, is subject to high international interest. We are now undergoing the process of cooperation between the EU, China, and the countries of Southeast Asia. There are several important integration processes going on. Last year we discussed the impact of those trends upon the national legislations, the issues of harmonizing and unifying national legislations with regard to relevant countries working in international unions. Today we can see some results. The Treaty of the Eurasian Economic Organization defines all the relevant concepts and identifies the applicable laws. We emphasize the concept of coordinated and harmonized policies. As is different from all the previous agreements, we have the new agreement on the free trade area and the single customs area, which fixes the right of the Union. It's again another proof of our striving to integration and common resolution of transboundary issues. When the treaty was drafted, some of the parties involved were apprehensive of a certain loss of sovereignty by the signatory states. But I would like to emphasize now that globalization is an inevitable factor affecting international relations, and it has generated new approaches to sovereignty. Globalization is speeding up, which greatly affects all the functions of states and their basic institutes, and their sovereignty, of course. But in spite of the multiple profound changes going on in the world for the last 10 years, the constitutional base of every state remains intact, as we can see. The states that cannot adapt their national policies to the versatile demands of the modern world cannot cope with the regional integration and cannot foster their national policies successfully. The need for global integration is universal, so we need to understand that it also has some negative impacts upon societal development. I am mostly referring to the idea of the loss of sovereignty is an incorrect one, because we are only talking of delegation of a certain amount of authority to integrated structures, which has nothing in common with loss of sovereignty. The Treaty of the Union identifies the regulators who will secure the rule of law for the Eurasian integration process as a whole. Sovereign rights and territorial integrity are among the provisions of the treaty for all the member countries. The purpose of the Union is purely economic. We target setting up stable conditions for the stability of economic development of every country and increasing the competitiveness of each economy of the sovereign member state. The regulator of the Union shall conduct ongoing monitoring for compliance with the global changes to ensure the stability of capital market and decreasing the competitiveness of the integrated economies. The Republic of Kazakhstan is now considering the possibility of setting up an international financial center, which was briefly mentioned by Minister Konovalov. This international center, as we hope, shall comply with the highest international standards and with the principles of transparency and non-discrimination. We plan to protect the users of financial services via judicial procedures. For that, we shall apply international law, and if needed, we shall introduce some constitutional changes in the legal framework of the Republic of Kazakhstan. We are introducing the position of investment ombudsman and of the business ombudsman, which will increase the investment attractiveness of the Kazakhstan market and of the EU as a whole. The treaty stipulates such principles as transparency of transnational legislation and securing accessibility of general laws and principles throughout the term of operation. We are introducing a regulatory mechanism for all the business entities to become part of drafting legislatory acts of the EU from the outstart of the draft of the lawmaking process. The legislation of Kazakhstan has adopted a similar tool. Thirdly, we must refer to the Court of the Union, which is designed to secure law enforcement throughout the Union and dispute resolution with the participation of member states and supranational entities for the benefit of the economic entities involved. One specific feature has to be mentioned here with regard to the transparency principle. This principle is only provided for the national legislations. In this part, I believe that we need a clarification. Transparency is required for the acts of the union bodies because it's an integrated part of the union law. Accessibility must be ensured via the national information, legal information system and via the EU systems. Next, we need to make all the regulatory acts of the Union in English to increase the attractiveness of our economic policies for other countries. I believe that the EU development shall generate a lot of interest from various global actors. To conclude, I would like to say that the development of the Eurasian Economic Union happens during the hard times of global recession. The member states shall be well prepared to tackle common issues and respond to common challenges. We are determined to overcome all the existing obstacles. All the stakeholders need to do all they can to implement very optimistic projections in the light of good neighborhood approach for the benefit of all our countries and citizens.
Thank you. Thank you very much. I think you have raised a number of very important issues in your presentation. These issues are among the most discussed issues today. Let me only add to that at this point in time, the Union has a mechanism of decision-making which is based on the interests of all the countries, all the Union members. So we obviously cannot have any loss of sovereignty. And I would like now to give the floor to the country which has always been very active in the integration process within the Union, the country which is now which is chairing the Eurasian Economic Union. I would like now to give the floor to the Deputy Minister of Justice of the Republic of Belarus, Mr. Tushinsky. Thank you very much. First of all, I would like to thank the Ministry of Justice of the Russian Federation for holding such a platform, a forum where issues of this kind can be discussed. This is the second time that we continue to discuss the issues of the Eurasian Economic Union. I was here last year, and I can see that we are trying to look deeper into this sphere. So once again, let me thank you, the Ministry of Justice of Russia, for providing us with this opportunity. And I'm very glad to see a wide range of experts joining us in the discussion. The Treaty on the Economic Union is the main topic here. But let me tell you that the President of Belarus, when signing the treaty last year, made a statement which can be boiled down to the following idea. Belarus has always stood for 4 freedoms: the freedom of goods, the movement of capitals, labor, and services. We do not see this at this point in time, and this is exactly why this statement was made. Moreover, our president, since Belarus is now chairing the main regulatory body of the Union, urged the member countries to intensify the process of creation of a joint market for capital, services and goods. Right now, the principle of free movement of goods is not functioning, and there have been some goods taken off the list. But when Armenia and Kyrgyzstan joined the Union, we can see that some of the positions will need to be taken off again. Medical equipment and medical drugs will be able to move freely from 2016. Energy issue remains high on the agenda of all of our countries, but we will get to the free movement of energy, and electricity will only be put into implementation in 2025. So basically we can say that the movement of goods is not free to the full extent. On our behalf, on behalf of our republic, we have always stated that it is important to move forward, and once we achieved one stage, we can move on to the next stage. The customs union, what's supposed to become the foundation for further integration, but that did not happen. The second point I wanted to make, the services sector. The unity is not so apparent. When the treaty was prepared, the services sector was divided into 4 areas. Area 1, the services that would be moving freely starting January 1st, 2015, and there are 44 items on the list, and that number of services will be now implemented. But in order for us to have a single market, we need to adjust our respective legislation. But we do not see anything being done on that front. The second area, the second package of services, has not been signed yet. The idea was to liberalize these services within a certain period of time. This second package will be discussed in Kazakhstan, and then it will be taken up to at the board meeting. The third package was signed, and also the treaty mentions the so-called sectoral market of services, which I call the eternal list, meaning that no one will ever let the other country get into that area ever. And this is something I mentioned during the last forum. We need to make sure that we agree on the division of powers, the division of jurisdictions, the division of our responsibilities, so that there were no budging in. The better we understand the division of competences, the easier it is to see the framework. It would be easier then to make decisions and act. Our treaty has the language about the competences which is not very clear. There is a reference to the functional part, but if you don't find it in the functional part, remains the competence or the competency of the national authorities. But we were very much against this. We in fact came up with a number of proposals. We came up with a proposal of which specific areas should be within the competency of the Union and which issues should remain within the competency of national states. In fact, our proposal was supported by the Ministry of Justice of the Russian Federation, but for some reason this proposal was not accepted. So the fact that there is not enough regulation in this issue leads to specific challenges, such as limitations on the movement of goods, and you may have heard some of the cases that took place within the past year. It would be best if such things were thought through before a decision is made. And the final point I wanted to make, it was already mentioned by Alexander, this is related to cooperation between justice ministries. It is important that the inroads that were made within the previous integration bodies were not lost, and so that we could build on them. We believe that the Union should have a complementary body, some kind of a conference of the ministerial level, and it doesn't matter what it is called, but the most important is that this kind of a body should make it easier to discuss and make decisions between the ministries. It is important that we discuss and keep track of our discussions. And this conference could help to define legal approaches to the process of integration. These approaches could be determined, defined, and further proposed to the executive bodies. I think that would be a great assistance for our legal process. Thank you very much for your attention. Thank you very much. As I said earlier in my presentation, starting 2015, the Kyrgyz Republic joined the Union, and we would like to hear from a representative of this republic. I would like now to give the floor to the Deputy Minister of Justice of Armenia, Mr. Kocheran. Thank you very much. Dear colleagues, a few months that passed from the moment when we signed the treaty on the Eurasian Economic Union, and this is not enough time to make conclusions or even conduct a full analysis. We are still at the early stages. Nevertheless, we believe this is a fine moment to meet with our colleagues, to check whether we are on the same sheet of music, and to discuss our visions of the integration process. And I would like to, first of all, express my gratitude to the organizers of the legal forum in St. Petersburg. Thank you for inviting me to be here and work at this very professional forum. I was very glad to listen to the presentations by my esteemed colleagues, and I agree with some of the points they made. And this is not an accident. The unity of our approaches, the closeness of our views is not only the result of our common interest in the Eurasian integration process, but also a result of the fact that our legal cultures and traditions are very close, and I think this is an important fact. Since we are rather short of time, I would like to give you a number of points, a number of ideas, very briefly, which in my view could be quite useful for our lawmaking process as we work within the Eurasian Economic Union. I believe that as we initiate and develop regulatory framework for the Eurasian Economic Union, we could use the principle of sufficiency as the main principle. We should also aim for proportionality and the balance between the national and supranational levels of decision making. Flexibility, proportionality, response to feedback should boost the efficiency of the decisions made within the Eurasian Economic Union. In this context, I believe we need to take into account the experience of cooperation that we've had within the CIS mechanisms. A lot of documents were signed within that framework, but their regulatory force was doubtful. In this context, we should also keep in mind the need to minimize stress for the businesses, for companies. Any new regulation that gets involved in the business area creates new opportunities, but it also may change the market. Small countries such as Armenia believe that almost any kind of economic activity is directly related to the external economic sphere, and the regulatory effect of the integration regulation will have a direct impact on a wide range of managing subjects and will cover virtually all the business field. In this connection, and we talked about that earlier, it is an important task to create mechanisms for informing timely and effectively the business community about those decisions that have already been adopted and those decisions that are in the pipeline. We need to avoid situations where the decisions catch some businesses by surprise, and therefore I believe that it is important to maintain consultations with business organizations and industry associations. It was already stressed earlier that it is important to maintain transparency and predictability in the regulatory control, and I believe this must be one of the imperatives of our work in the future. In the same vein, I can share our national experience. For a long time, we have worked on the basis of a mechanism of the so-called regulatory guillotine. Under this mechanism, the regulatory acts were subjected to expert review and, if necessary, were revised. The criteria for the review and the appropriate cut-off provisions were simplicity, accessibility, transparency, and the speed of decision-making mechanisms. I believe that the same criteria could be applied to the rule-making process of the Eurasian Economic Union. As we develop technical and industrial regulation within the Eurasian Union, it makes sense to think about some cases that could be used as a reference. We should use positive experience as a reference, and I mean the experience of approximation, harmonization of legislation of other integration associations, namely the European Union, which, in spite of the changing political environment, is one of the largest trade partners of the Eurasian Union. And it is an association which thousands of enterprises from our countries work directly with. The standards and regulations of the European Union that were developed over decades concern a wide variety of fields and industries, and they could be used as a good tool and as an incentive for rule-making work within the Union. But obviously we need to take into account our specifics. We need to make sure that we take into account what is necessary and appropriate. In presenting this vision of the legal aspects of the Eurasian integration, I would like to also briefly touch upon the circumstances relating to Armenia. It is known that Armenia, being a member of the Eurasian Union, has no common borders with the other members of the Union. And as far as I know, this situation is unprecedented in the experience of world economic integration organizations. This obviously leads to a number of challenges, but we in Armenia are definitely committed to overcoming these challenges, and we want to continue our work with our colleagues and partners from the Eurasian Union. At the end of my speech, I would like to express my confidence that our joint work and coordinated efforts will lead us to the desired result: the effective legal integration, the establishment of our legal system that would function for the benefit of all of our countries, members of the Eurasian Economic Union. Thank you.
Thank you very much, Deputy Minister. And I would like to grant the floor to the Deputy Minister of Justice of the Russian Federation, Mr. Travnikov. Thank you very much. For the whole of the last year, the Eurasian economic space has been working under the auspices of setting up the new Eurasian Economic Union. But once we have achieved that goal, we have not really completed our new work. We have just started it. We had to draft a lot of documents, including the treaty. But we didn't have to start from zero. To a large extent, we have taken advantage of the legacy of the Eurasian integration, of the many years of Eurasian integration. I'm talking of the customs union, the single economic space, and many other documents and structures that facilitated our EU work to a great extent. The treaty has greatly enhanced our integration as compared to EurAsEC. But many of the lines of the integration that formerly existed in EurAsEC were left aside for our new format of integration. The humanitarian area is one of such examples, and many other areas related to legal cooperation. For example, the forensic area, the forensic inspection. The new organization called for a new court. So we had a lot of discussions as to whether or not the EurAsEC court could proceed with its operations. And the final conclusion was that no, we need a new court, since the new union is a largely different entity with a lot of new specific features. So we had to draft the annex to the treaty, and that went in parallel with drafting the treaty text itself. And a lot of amendments have to be made after the wording of the treaty was completed, just because we wanted the statute on the court to be eventually annexed to the body of the treaty. So we were based upon the documents of EurAsEC court, and we made it our starting point to take advantage of the positive experience of all the EurAsEC documents and structures. And you will see some of the provisions very clearly transplanted into the court, in EU court regulations from the EurAsEC court regulations, but lots of the EU court provisions are totally new. The Commission of the EU is one of the reasons for that. The new court regulations had to accommodate the activities of the Commission, and we needed to get agreement of all the relevant parties. We still have this option as an open option, but we believe it will eventually be used. The larger treaty is like something of a constitution of the new EU. The model of the new court was actually designed similarly to the constitutional court, which means the court does not create any law, it does not make any law, it does not cancel any existent rules or laws. That is the responsibility of the relevant states. But the Court of the EU only decides upon the compliance of the provisions to the Union legislation. There are two categories of cases to be considered by the Union Court. The first one is resolution of conflicts between the member states with regard to treaty provisions application, and the conflicts between the disputes between the economic entities, whether if they are willing to claim to challenge the decisions of the court. Also, the court can issue decisions to the member states with regard to application of the treaty. It's necessary to say that this does not cancel the sovereign right of the member states to interpret the treaty. But of course, it would be right to have those processes interrelated tightly. And in this regard, I would like to point out a pending issue, which is ensuring clear links between the national jurisdictions and the EU court. I am convinced that this link should be clearly defined and hierarchically structured. in what concerns the competences of the Union Court. I believe that the Eurasian Economic Union Court should be considered as a final court, and we need to understand that we need a clearly structured interaction lines between the national courts all the way up to the EU court. The national courts should be granted access to consultative opinions from the EU court with regard to the treaty provisions application. That will allow us to have uniform juridical practices throughout the EU space, and that will help us to avoid conflicts between the national jurisdictions, national courts, including the constitutional and supreme courts of the member states, and the EU court. As of today, this remains a pending issue, but I believe there is no deadlock. We shall move on to the final resolution. Another important point, the competency of the court was from the outstart formed in an open way. The court can apply not only the treaty and other agreements that are part of the Union law, it can apply any international regulatory acts that can benefit interpretation of the Union legislation provisions. And here we refer to the regulation of personal rights and freedoms, the rights and freedoms of the citizens, and the rights and freedoms of the states. The legal procedure has a novella, which is specialized groups. That's a very special format designed for most complicated cases. It supports the court in coming up with their positions. This may largely relate to industrial subsidies and compensations. This is the subject of a special chapter in the regulation and in the court statute. But apart from the statute, there are about a dozen documents regulating in detail the different aspects of court operations. The second half of the year, the working group, which I'm honored to head, was spent in preparation of those documents. Most of those documents have been completed, with the exception of the ones relating to paying for the experts' services. The experts working at interstate conflicts. I would not like to abuse of the time allowed to me, so to conclude, I would like to say that we believe that the states who drafted the documents have managed to maintain the consistency between the EurAsEC and EU courts procedures. Lots have been maintained and very little has been lost. We are proceeding with enhancing the competences of the court. Once we identify the issues to be resolved by the states jointly or in a coordinated way. We are not yet sure the way it will work in practice. The court is only just starting to operate. But we understand that all the Union member states believe that it's our duty to provide guarantees of proper application of all the documents regulating the operations of the Union. But it's still a living document drafted to regulate living relations. It's amendable, and further on we shall make it accommodate some more regulations, and perhaps the statute may be further amended if needed. We shall negotiate those needs. I would like to thank once again members of the working group and the negotiators for the treaty and for the court statute. I would like to thank the judges attending this meeting for their informal help and for their reviews. I would like to thank the Secretariat who will go on with our further work. Thank you. Thank you very much.
Thank you very much. Indeed, you have mentioned a number of very important issues. Colleagues, the Court of the Eurasian Economic Union is one of the most important bodies of our union. It ensures efficient workings of the legal mechanism, and we should not underestimate it. I would like now to give the floor to the chairman of the Court of the Eurasian Economic Union, Mr. Fedortsov. We would be happy to listen to your opinion. Thank you.
Dear colleagues, thank you very much. I'm happy to welcome you on behalf of the Court of the Eurasian Economic Union. All the judges of the court are now in St. Petersburg taking an active part in the 5th International Legal Forum. The judges of the court are members of the Expert Council of the forum. They're making their presentations and reports, which means the court is trying to contribute to the success of the forum. The Eurasian integration topic is greatly in line with the purposes and goals of the forum, which is a unique platform for discussion of the topical legal issues in the context of the global social and economic tasks. For the last 20 years, starting with the agreements on the customs union of years 95, 96 and 99, proceeding with the EurAsEC Treaty of year 2000, the Treaty of the formation of the customs union of 2007, the Eurasian states are moving towards enhancing and expanding its integration cooperation. The climax of the integration as of today is, of course, the Treaty on Eurasian Economic Union, signed by member states in Astana exactly 1 year ago, on the 29th of May 2014. In line with the agreement, in line with the treaty, the union came into force and became operational on the 1st of January of 2015, as well as one of its constant bodies, the Court of the Union. Now let me dwell upon the legal basis of creating, organizing and operating the court. The legal basis of it is, of course, the statute of the Court of the EU, the regulations of the court, and the resolutions of the Supreme Eurasian Economic Council adopted under the implementation of the treaty. The direct implementation of the provisions of the treaty are the resolutions of the 23rd of December 2014 on adoption of the regulations, then the appointing of the judges, and the Court of the Eurasian Union has been carrying out its direct activities starting on the 1st of January 2015. The jurisdiction of the court includes consideration of disputes of international under the Treaty of the EU, of the international agreements and decisions of the bodies of the Union. The applicants to the court may be member countries and economic entities. For the member states, the right of application relates to a lower number of preconditions. They can turn under the international agreements or the individual provisions of the treaty. But for the other applicants, the preconditions are different. They can go by the decisions of the individual bodies of the Union and the Commission's decision under the international agreements. They can also challenge action or inaction of the Eurasian Economic Commission. But the entities can only litigate in court the resolutions or action or inaction of the Eurasian Economic Commission with regard to its compliance with the treaty. But not any resolution can be litigated in court, but only the resolutions that touch upon the legitimate rights and interests in the area of entrepreneurship or other economic activities, and only in case if the challenge, decision, action or inaction of the Commission have entailed offense against the treaty or agreements against the rights or legitimate interests of an economic entity. The statute of the court provides for possible extension of the court competences, but point 41, item 41 of the statute of the court specifies the applicable law, paying attention to the fact that the definition of the court competences in dispute resolutions shall only apply the provisions of the Treaty of the Union, international agreements under the framework of the Union, and international agreements of the Union with a third party, which is different from the applicable law to carry out justice, to exercise justice under the international custom. For applicant states and economic entities, there is a provision for pre-trial procedure for conflict resolution. The deadline for that is extended to 3 months. Apart from the competency of conflict resolution, the court is also authorized to consider the applicants of a member states, to consider applications of a member states for interpretation of regulatory provisions of the Union. Similar interpretation competency shall be exercised against applications from public officials in relation to labor legal relations. Now, the judicial procedure. The key here, procedures for justice for the justice are such principles as the equality of parties, competitiveness, openness of trial, independence of judges, collective nature. The court considers hears cases by the judicial bench, by the Chamber of Appeal, and the Ground Judicial Bench. The judicial bodies are in demand, including from beyond the Eurasian space. The EurAsEC court, during the 3 years of its operations, considered 32 applications. The EU court has already considered 3 applications. Apart from the member states, the applicants came from Germany, Ukraine, India, and China. We need to accommodate the practices of the EurAsEC court and the EU court to secure in-depth penetration into the integration processes. We should not exempt any applications, and we should be very careful about rejecting applications. The court is working at recommendations for applicants, but at the same time, we need to say that the integration legal documents are not sufficiently studied by the economic entities. A good qualified union court shall play an important part in the integration processes, and not only in what regards conflict resolution. It should facilitate harmonizing the constitutional regulations and promoting the union's further integration and economic development. Uniformity of law enforcement is another target. For that, we need to increase the competences of the court and eliminate some of the overly prerequisites for court applicants. Thank you very much, Dr. Fedortsov. I would now like to develop on another important issue, which is the protection of union markets. Very often we can see unfair competition on behalf of the companies and businesses from the third countries. According to the Union Treaty, the union documents shall protect the internal union market. The Commission attaches great significance to this issue. With this regard, I would like to grant the floor to the Director of the Department for Domestic Market Protection of the Eurasian Economic Commission, Mr. Ilyichov.
Thank you. First of all, I would like to thank all those who came for your interest in the Eurasian Economic Union and the integration process. I would like to speak about the internal market protection, but also about what happened when the treaty came into effect, when we started regulating the exchange of products. I work in the trade department, and therefore I work mostly on the trade issues, not only market protection measures. First of all, let me say that now that the treaty has a number of new regulatory norms, and these regulations provide for a single foreign trade policy, the system and the environment of decision-making in the area of foreign trade policy has changed dramatically. Now we have a principle which says that we have now one single policy, as apart from other areas that were provided for in the treaty, such as areas where some competences were given to the national states and some to the Union. The treaty also established a number of new instruments that have become an area of discussions for the Commission. The export support measures is one such example, and the Commission is looking into all these issues, trying to organize joint efforts by export agencies and other institutions, for example, export credit and export insurance agencies. We hope that very soon we will see some results of these joint efforts. Hopefully, they will be beneficial for the export of goods and services from the Union. The treaty also introduced a number of response measures, instruments. These instruments are called to facilitate the implementation of obligations of the third parties. And we now are in the process of discussion with the national authorities, looking into cases when our partners did not perform on their obligations. It is also important to note that some changes took place where other measures of market protection were mentioned, measures that are required for the efficient functioning of the economic free zones. Well, I have to say that the treaty has brought in some order and systematized the achievements that were made in the previous associations. At the same time, it clarified a number of ideas. For example, areas where there were some disputes in terms of division of competences. I would like to say a few words about the free trade areas. The treaty specifies what this regime is all about, and further documents regulate negotiation process. We are now concluding the agreement on the free trade area with Vietnam. Hopefully very soon this agreement will be signed. Negotiations are ongoing, and this particular agreement for us is a new stage for the development of our relations. It was not very easy to reach this agreement, and in a way it is a pilot agreement. Vietnam was selected as a partner because it's a very clear and transparent step, and the consequences of this agreement are quite clear and transparent as well. At the same time, the agreement itself is a very important and very new step forward for all of our colleagues and for all of the members of the Union, because it covers a wider range of issues compared to usual agreements that we had in the past. The agreements that were signed at the national level. For example, this agreement not only defines the free trade area as an area where almost the entire list of goods will be traded freely, and we hope that we will increase the trade volume with Vietnam. According to our calculations, the increase may be quite significant. But this agreement also touches upon a number of other issues. The protection of competition, customs cooperation, introduction of a electronic information exchange system whereby customs operations information will be exchanged. Other novelties were introduced in terms of sanitary measures. And it is also important to note that a number of agreements were reached by several countries, such as the Russian Federation, with Vietnam in terms of services regulation. When the agreement was signed, we did not have too much time to use it, but there were a lot of events, a number of developments that took place, including the expansion of the Union, the accession of Armenia, and we expect that Kyrgyzstan would also become a full member very soon. Hopefully, this will lead to a number of changes in the trade policy as well. That will result in some changes in tariff regulation and customs regulation provisions. One of the changes concerns the obligations of WTO members with regard to their tariffs. I have to say that WTO plays a very important role, since their rules are directly applicable. And there's a lot of coordination with the customs union regulations, and this is very important for us. Let me tell you that the customs tariffs change on a regular basis in order to make sure that the tariff classification meets the obligations of the Russian Federation. And now on to the protection measures. This is my direct area of expertise. Let me tell you this. The fact that the treaty has come into force was very important for us, because we did work together for a while before the treaty came into force, but the treaty itself and the annexes with the protocol on the protection measures contained a number of new elements. In a way, these elements facilitate our work, but in a way also these elements change the way we work. We have reached a number of conclusions with regard to the need to change some legislation, especially legislation that concerns court procedures. There were a number of novelties there. In fact, we have had 3 cases taken up by the Eurasian Association Court, and there were anti-dumping measures that were discussed. Well, in any case, the fact that the treaty came into effect cleared up a lot of unclear areas and closed some of the gaps in terms of how certain cases can be resolved in court. A number of special procedures were determined, including procedures for the protection of anti-dumping measures. A lot of our proposals were taken into account. They were introduced into the treaty, and hopefully the process will become more clear, more transparent, and easier to understand for all the participants. And now a few words about the number of applications. Number of applications on the special protection measures, anti-constitutional and anti-dumping measures. So this number is growing on a constant basis. This court is becoming more and more popular, so to speak, because we cover a wide range of sectors, and there are a lot of sectors that are interested in taking up their cases to the court, and that includes machine building, textiles, chemistry, consumer goods such as cutlery and pottery. The number of applications is growing. We believe it is an important tool, and hopefully there will be more developments in the nearest future. Even though the procedures are very detailed, the requirements are very specific in the protocol, as well as in other documents. We still think that there will be new developments in the future. Thank you very much. Thank you, Vladimir. Colleagues, we have exhausted the list of speakers for this panel discussion. If you have any questions to the participants, to speakers, we would welcome your questions. If there are no questions, then I would like to thank, on behalf of all the panelists, to thank you for coming. I think we've had some very interesting discussions, some very interesting presentations. I would like to wish you all good luck in whatever you do, and fruitful discussions during this forum. Thank you, and I'm being prompted by the organizers to say that a coffee break is now on, so we invite you all to have a cup of coffee or tea. Thank you very much.